Hey everyone, welcome to tonight's lesson on the Martial Court. I'm trying to present, but when I do, it takes over my whole screen, and then when I do that, I won't be able to see your questions, so I might have to show you my slides almost in non-presenter view, which I hope doesn't make the slides far too small for all of you, but for whatever reason, it's being really wonky tonight, which is kind of annoying. But anyway, tonight is going to be all about Martial's Court. Think Vibable. So just remember, you can always get to us on Twitter, Instagram, or on YouTube. Hit us up with questions there, topics you might want us to cover, or just spread your love for Vibable at all times, which is always a very cool thing to do. Just to give you a heads up of different presentations that will be coming your way. So we have coming up Rise of Political Parties. And that'll be on October 16th, 7 p.m. Central. So that's literally right after this one. Then tomorrow will be Regionalism in early 1800s and the War of 1812. And that'll be at 6 p.m. Central. Next week, on the 21st, the Market Revolution at 7 p.m. Central. Key Documents and Age of Jackson on the 22nd at 7 p.m. Central. Manifest Destiny and its Impact on October 23rd, 7 p.m. Central. This is Frankie. And then Writing in Period 4 on October 24th. So that's next Thursday. I will be back to talk about Writing in Period 4, 7 p.m. Central. And just so you know, for that one on Writing in Period 4, we'll be looking at all the different writing. So we're talking about short answer questions, long answer questions, and then we'll also be talking about those document-based questions that I know are a fan favorite for everyone. Before we get started, if everyone who is kind of out there right now, why don't you just introduce yourselves real quick, kind of give us a heads up as to who's watching, where you're from, just so I have a good idea, and then we can get started. And please, as we're going on tonight, don't hesitate to ask questions. What I'll do is try to get to them at the end of each slide. But definitely as you're watching, feel free to ask questions. Hey, Zoe. Hey, Vicky. Oh, California. Junior. Okay, so we have juniors and seniors at my school. It's a mixed class taking APUSH. So seniors who didn't take history last year will take it this year. And Myrtle Beach, South Carolina. Very cool. I'm in New Jersey, where it's pouring rain right now. Hey, Miami. I'm jealous of you folks in the warm locations. You'll see my cats running back and forth, and they've been kind of in an extra pain mode lately. So welcome to all of you, and thanks for joining. So let's just jump into what tonight is going to really look like. So we're going to start off with who is John Marshall anyway, right? We're going to be spending all this time talking about his court. We should probably have some basis of who he is as a person. And then the super important court cases. There are a lot of important court cases for APUSH, but it is truly fascinating how many of those court cases took place while John Marshall was Chief Justice. So the very first one we're going to talk about, which kind of sets a precedent for later court cases, will be Marbury versus Madison. We'll jump into McCulloch versus Maryland, Dartmouth College versus Woodward, Gibbons versus Ogden, Cherokee Nation versus Georgia, and then Worcester versus Georgia. We'll talk about the lasting impacts of the Marshall Court in general. And then I have 3 multiple choice questions based on one passage from John Marshall. And we'll take a stab at that just to see. It'll be based upon stuff that we go over tonight. So it'll give us a good idea of how tonight is going, so to speak. So let's not waste any time here and talk about Mr. John Marshall. So John Marshall, he's Chief Justice of the Supreme Court from 1801 to 1835. So he is on the Supreme Court for quite some time. He's a Federalist, which is going to become important when we talk about our very first case of Marbury versus Madison. We'll see that his court decisions really created basis for constitutional law in our country. Frank, come on. So you'll see a lot of the decisions that are being made today by our Supreme Court, even though they might not be on the same topics covered in the Marshall Court, it's the precedents he set about how you handle cases in general that are still used by our Supreme Court today. And you're going to see that he makes, I'm sorry that he's sticking butt, like right in front of the camera. He's going to make the judicial branch equally powerful to both the executive and the legislative branch. And that's going to be super important. I mean, it's what our founders wanted, right? These three equal branches of government. And we're going to see that he ends up doing that. So we're going to go right into our first case here, Marbury versus Madison. Oh my God, Frank. So Marbury versus Madison, you'll see I put some side notes here, just some basic facts about the case that are very helpful, but I'm going to, obviously give a much longer spiel. So as I'm going, Frankie, for love, as I'm going through this, I don't know if you all have pets that get annoying like this. As I'm going through this, please don't hesitate if you have a question. So just to give you some background on Marbury versus Madison, okay? We have Thomas Jefferson. He's just been elected president. Back during this time period, the new president, so he's elected in November of 1800, right? But the new president doesn't get sworn in until March of 1801, which means John Adams, who is still our president, he's going to be in office for a few months before he leaves. And a lot of times when that takes place, they're known as lame duck presidents. Because sometimes things just don't take place between when they lose the election and then like the new president is coming in. Well, in this case, what we see is that the Congress, prior to Thomas Jefferson coming to office, Congress is going to pass a law that's known as the Judiciary Act of 1801. And what this law does is it creates new judgeships in our country. And by creating new judgeships and creating more courts, that means that John Adams is going to have to appoint new justices before he leaves office. And just keep in mind the process for appointing a justice is that the president nominates a justice and then the Senate needs to confirm that justice. So we're seeing this happen where John Adams is making a lot of appointments prior to leaving office. They become known as midnight judges or midnight appointments. Is he literally doing this like at midnight before he leaves office? No. But he is doing it in the weeks and the days prior to leaving office, which is why they get that name, midnight justices or midnight judges. One of the people who receives this appointment is a gentleman by the name of William Marbury. So William Marbury, he's a Federalist, and that's one of the things that John Adams wants to do. It's one of the reasons why we see Congress pass this law is because in the election of 1800, the Federalist Party has lost the executive branch. They've lost the legislative branch. They feel like appointing a bunch of Federalist judges is their way for the Federalist Party to still have a say in some part of the government. So William Marbury, he gets appointed from Adams. And to receive his commission, he's supposed to receive like a commission, like basically a piece of paper saying, hey, William Marbury, you've been appointed. But he doesn't end up receiving this commission prior to Adams leaving office. So technically, the new president, who's Jefferson, should have his Secretary of State deliver that commission to Marbury. So Jefferson's Secretary of State is James Madison. And Jefferson decides to tell James Madison, don't deliver the commission to Marbury, just because it was kind of shady the way this all went down last minute. He shouldn't be becoming a judge. So Marbury decides he's going to sue James Madison because in his mind, he deserves that commission. James Madison as Secretary of State is his responsibility to deliver it. So Marbury sues Madison, which is why it's known as Marbury versus Madison. And he uses what's known as a writ of mandamus to compel Madison to act. And that's his reason for suing. And so basically this writ of mandamus comes from the Judiciary Act of 1789. It's a little part of the Judiciary Act of 1789. And basically what it says is the court has the power to force somebody, like a government official, to commit a certain action. So in this case, Marbury is going to the court and saying, listen, Supreme Court, I am compelling you to force James Madison to give me my commission so I can become a federal judge. And so it goes through Supreme Court and they have to, talk about what's going to end up happening. And so what the Chief Justice, John Marshall, does is he recognizes that this is really a huge dilemma, right? So if he goes with if he goes with Jefferson and says with Jefferson, no, this guy doesn't deserve his commission, right? And says, listen, the court has no power to enforce under the writ of mandamus. The court has no power to do this. In a sense, he's kind of taking away power from the court, right? Because that's a huge power that the court would have to force government officials to commit a certain action. And he's a Federalist, and the Federalists believe in a strong federal government. So one would think that's what he's going to do. But then he also has the option to say, yeah, listen, I believe that the court should be allowed to force somebody to do something. I'm going to uphold the writ of mandamus, which is going to give us this awesome power as a Supreme Court. And therefore, Marbury should have to take the position. Well, in the end, what he decided to do was come up with the concept of what's known as judicial review. And judicial review is the idea that the Supreme Court has the power to rule whether or not a law by Congress, an act by the president is constitutional or unconstitutional. By telling Marbury, listen, you actually don't have the right to bring this court to us because I'm telling you that the writ of mandamus is unconstitutional, he gave the Supreme Court its greatest power, which is this idea of judicial review, that they can say whether or not a law by Congress or whether or not an act by the president is constitutional or unconstitutional. And that's the greatest power a court has today. And that concept of judicial review, we're going to see in several of these other cases that we're going to talk about today, where basically that's what the Supreme Court is doing. They're looking at different laws and saying, yeah, this is in line with our Constitution, or no, this is not in line with our Constitution. So in the end, to sum it up, Marbury does not get his commission because we have Chief Justice John Marshall saying the way you brought it to the court case wasn't constitutional. The way you brought the case to court was not constitutional. This writ of mandamus from the Judiciary Act of 1789 is completely unconstitutional. The court should not have this power according to our Constitution. So I know that's kind of a little bit confusing, so I want to pause for a second just to see if you have any questions. Sometimes when, so I already taught this court case to my students, so sometimes when you teach it so much, you say it really fast, so that's why if you have questions, don't hesitate to ask. But if not, we will jump right into our second case, which is going to be McCulloch versus Maryland, and this has to do with the Bank of the United States. So McCulloch versus Maryland, 1819, the Supreme Court has to look at whether or not the Bank of the United, well, they're looking at two things. One, they're going to look at whether or not the Second Bank of the United States is constitutional. And the second thing they're going to look at is whether or not state governments have the right to tax federal governments. So the biggest issue in this case is the constitutionality of the Second Bank of the United States. Now, if you recall, in 1811, the First Bank of the United States had expired, the charter. But part of Henry Clay's American system was to recharter the Bank of the United States and call it the Second Bank of the United States. So in 1816, we have the start of the Second Bank of the United States. And what we see is the fact that the state of Maryland is going to try to charge, because the Second Bank of the United States is located within the state of Maryland. So the state of Maryland is going to try to charge taxes to the Second Bank of the United States and say, hey, Second Bank of the United States, you need to pay these taxes. And so the bank refuses to pay the tax, right? And the cashier of the bank was James McCulloch. So Maryland is going to basically say, listen, you need to pay your tax. And they end up suing James McCulloch, saying you need to pay this tax, you're in debt to us. And McCulloch responds by saying, no, I don't have to pay the tax. The tax is unconstitutional. And in the beginning, we're going to see that a state court, because remember, you don't just jump right up to the Supreme Court, you go through a bunch of different courts. So in the beginning, a state court for Maryland is going to affirm that. And then we're going to have McCulloch. So in the beginning, they're ruling for Maryland. And then we're going to have McCulloch take it to the Supreme Court. And so now the Supreme Court is going to look at this court case. And it's going to end up being a unanimous opinion written by Chief Justice Marshall. And it rules that the Bank of the United States is completely constitutional, and that the Maryland tax, because remember there's two questions that we're looking at, the Maryland tax is unconstitutional. And so let's start with the constitutionality of the bank. So yes, the bank is constitutional, and John Marshall uses that famous necessary and proper clause, right, which has the nickname of the elastic clause, which comes from Article 1 of our Constitution, Section 8, which gives Congress its powers. And it says that Congress has the power to pass laws that are necessary and proper for the execution of their enumerated powers. So let's think about some of these enumerated powers. The enumerated powers of Congress, oh my God. The enumerated powers of Congress include the power to regulate interstate commerce, collect taxes, and then borrow money. So basically what they're saying is the bank is necessary because in order to fulfill these powers of regulating commerce, collecting taxes, and borrowing money, you need a government bank to do so. So they're saying it's completely appropriate for Congress to have completed this, for Congress to have created this bank. The second thing that the court had to look at was whether the state of Maryland had the power to tax the bank. And so what the court says is, according to the Supremacy Clause, the Supremacy Clause being Article 4 of the Constitution, it says that our federal government laws trump our state laws. And so the famous quote that John Marshall says to this is the fact that, I think I put it on the slide, he says the power to tax is the power to destroy. So basically he's saying how great of a gift the power of tax is, and that a state law can never supersede or trump over a federal law. So therefore, in this case, that state tax of Maryland trying to tax the federal government is going to be considered unconstitutional. And so we see, again, they're using judicial review, which was the power granted to them in Marbury versus Madison decision. They're using that to rule on the constitutionality of the Bank of the United States and on the constitutionality of the state law of whether Maryland has the right to tax the bank, which is a federal government entity. So two super important cases that, again, kind of set a bedrock for us as far as our constitutional law moving forward in our country. You find this super interesting, Frank? Any questions before we move into our next court case? Okay, so then moving into our next case, we're going to have Dartmouth College versus Woodward. And this is also going to take place in 1819. So the Supreme Court really keeping busy at this point in time. So basically, this case is about New Hampshire, the state of New Hampshire. They're trying to convert a private college into a public university. So Dartmouth College is founded, come on, Frank. It's founded by Congregational Minister Eleazar Wheelock. And basically in 1769, so Dartmouth College has been around for some time at this point, he received a charter from the English Crown that allowed him to create this board of trustees, which would then in turn end up creating Dartmouth College. So when the American Revolution came to an end, this college would sometimes receive money from the state of New Hampshire because Dartmouth is located in New Hampshire. But it was still controlled by a board of trustees who kind of continued to look at the original religious mission that first established Dartmouth. What we're going to end up seeing happening is that in 1816, Democratic Republicans in the state legislature amend the college's charter and attempt to convert the school from being a private religious school into a public secular institution, meaning no religious basis to the school. And a lot of this had to do with party politics. So in the beginning, for the longest time, the board of trustees were Federalists. So in 1816, we're now seeing a Democratic Republican legislature. So just know there are some party politics involved here. So what this new state legislature does, though, is they create a new board of elected trustees. Even though they have this new board that the state legislature assigned, the old board, the original trustees, are continuing to operate Dartmouth College. And so it becomes this infighting between these basically two different boards of the original trustees and then the new trustees, and whether or not in the end the state legislature of New Hampshire has the right to take a private college, a charter for a private college, and turn it into a public institution. So the original trustees, the folks who were there, and want to keep it private, they're going to argue that the legislature have violated their vested rights, that they have violated the state constitution and the U.S. Constitution's contract clause, because they're basically looking at this charter that they were given way back when and saying that charter is technically a contract. A state court is going to side with Woodward, declaring that college a public corporation, so therefore it made it subject to state legislation. The Supreme Court, though, we're going to see reverse this decision. So in the opinion for the Supreme Court, Chief Justice John Marshall, once again, wrote that by establishing a corporation, Wheelock, who was that original trustee, had created an artificial being, intangible, these are his words, an artificial being, invisible, intangible, and existing only in contemplation of the law. So basically what he's saying is that New Hampshire was violating Dartmouth's charter. Marshall concludes that Dartmouth's charter constituted a contract, which is what they were arguing, and that New Hampshire had violated this contract in trying to replace the original trustees. And so this is a very huge warning to states as far as what else they were going to do. Frankie, please. Because basically what this is saying is that when you have a contract like that, the state governments cannot try to supersede that contract, that contract is law. And so they need to follow that law in a sense. So we're going to see that they rule in favor of those original trustees for Dartmouth College. Questions? Okay, so we're going to continue on to our next case, which is going to be, so this is going to be Gibbons versus Ogden. It hits home since I'm from New Jersey, and this court case somewhat takes place in this area of New Jersey. So this is going to be in 1824. And basically, this court case is about steamships. So steamships that were traveling in between the state of New York and the state of New Jersey. So the state of New York gave Aaron Ogden an exclusive license to operate steamboat ferries between New Jersey and New York City on the Hudson River. So it's basically like Ogden had a monopoly of steamships on the Hudson River. Thomas Gibbons, who also was a steamboat operator, he was running two ferries along the same route as Ogden did. So Ogden basically sought what's known as an injunction, which is a way to stop Gibbons from being able to run a ferry at the same time that Ogden is running the ferry. So Ogden goes to the state of New York and to their courts, and he says, listen, Gibbons can't run his ferries. New York State had given him exclusive rights to operate that route between New Jersey and New York on the Hudson River. So Gibbons needs to get off the river. So Gibbons' response is the fact that he has the right to run a ferry business because it's going between states. And so that's interstate commerce, right? Because it's between states. And so therefore only the federal government can regulate that and the state can't regulate that. So the New York court in the beginning rules for Ogden. And they told Gibbons, listen, you have to cease and desist, no more operating steamships. We're going to see that it's going to go to the New York Supreme Court, and the New York Supreme Court is also going to rule in favor of Ogden. So Gibbons will appeal this case to the U.S. Supreme Court. And so this is interesting, right? These last couple cases, we see that when they go to lower courts, the lower courts are all ruling one way. And then once they get to the Supreme Court, John Marshall is overturning all those rulings. So it's going to get to the Supreme Court, and Chief Justice John Marshall is going to rule in favor of Gibbons. He's going to say that New York's exclusive grant to Ogden violated the Federal Licensing Act of 1793. In reaching its decision, the court interpreted the Commerce Clause of the U.S. Constitution for the first time. So we have this commerce clause in our Constitution. We've never had any ruling as to what it means. This is the first time where we're going to see the court interpreting it. And so the clause, just so you know, reads that Congress should have power to regulate commerce among the several states. So according to the court, the word commerce included not just like items, so not just like food or tea or anything that's being traded between states, but it could also include navigation of ships. So in their mind, when a person is purchasing a ticket to get on a ferry, you, in a sense, are becoming a unit of trade because you are paying for that ticket to cross state lines. And so this is expanding. This case is huge because it's expanding the definition of commerce. And it means that Congress is going to be able to get involved in a lot more when it comes to regulation and making laws besides just what we might commonly see as trade. And this is going to be interesting as you all continue on in your APUSH studies, because you're going to see that commerce, as technology has increased, commerce is going to quickly, that definition is quickly going to begin to expand. We're going to see during the civil rights movement in the 1960s that they're going to actually use the Commerce Clause to desegregate some restaurants and hotels. We're going to see today that the Commerce Clause is sometimes used for regulations of businesses' emails and different transactions. So it's very interesting. This is the first case that really starts that expansion of what commerce, what is going to fall under commerce and what is going to fall under trade. And it's going to have huge implications moving forward in our country because of the fact that we're going to see more and more falling under that classification. Questions about Gibbons versus Ogden before we move into two very important Native American cases. All right, cool. So our very first case that we're going to be looking at is Cherokee Nation versus Georgia. And this is going to be in 1831. And I mentioned there's two important Native American cases, so there's going to be a second one followed up to this. So in 1828, oh my gosh, come on, Frank. The state of Georgia is going to pass a series of laws stripping local Cherokee Indians of their rights. So we have a large population of Cherokee Native Americans who are living in Georgia. And so Georgia is going to start passing these laws to take away rights from these Cherokee Native Americans. The laws that they begin passing also authorize Cherokee removal from lands sought after by the state. So Georgia wants more land for its white citizens. So they're going to pass laws to remove the Cherokees who are living there and basically push them west. So these are state laws, but we know Andrew Jackson, right, is also doing the same thing with the Indian Removal Act that we're going to see in 1830 that's going to come about, also trying to push Native Americans off the land and west of the Mississippi River. But let's just focus on Georgia for now. So in this court case, we're going to see that the Cherokee are going to cite treaties as to why these laws cannot be put into place. So the Cherokee have treaties that they've signed with the government, that they had negotiated with the government, saying that the Cherokees are an independent nation, that the United States would recognize them as an independent nation. It would recognize that they had rights to that land. And because they are an independent nation, they do not have to follow these laws that Georgia is passing. But what we're going to end up seeing happen is Andrew Jackson is the president at this time, right? Because Andrew Jackson wins in the election of 1828. And Andrew Jackson is not very much a fan or a helper of Native Americans. So we're going to see the court in Cherokee Nation versus Georgia rule that it lacked jurisdiction to hear this case and could not resolve it. The court began by saying that they sympathize with the Cherokees, right? We kind of feel your pain and we're sorry for what you're going through. They even went so far as to saying that we know you've been persecuted and marginalized by European settlers for years. And then they asserted that the Native American nations were both foreign nations and people within U.S. boundaries. In other words, the Cherokee, those sometimes viewed as an independent nation, were also dependent people on the United States as well. And so because the Constitution only authorizes the Supreme Court to hear cases brought to it by, I'm sorry, I'm getting confused by my notes here. But because the Constitution only authorizes the Supreme Court to hear cases that are brought by citizens, the court was not authorized to entertain this case, and they end up dismissing it. Meanwhile, we're going to see, so that's, before I go into the meanwhile, that's Cherokee Nation versus Georgia. Basically, the Cherokee Native Americans don't want to follow Georgia laws because they say we have these treaties that say we are an independent nation, and therefore, as an independent nation, we don't have to follow these laws. Goes to the Supreme Court, and the Supreme Court says, listen, because you are considered to be a foreign nation, you cannot bring your court case before us, is basically what the Supreme Court is saying. So they can't, so they're saying we can't even make a decision on this case, but we feel bad that you're going through all this. A similar case to this, which is also going to take place in Georgia and kind of backs up to this, is Worcester versus Georgia, which is going to be in 1832. And so this is a similar case. What we see with this case is the fact that we're going to have, let me get into background on this case before I say the ruling. So we have white Christian missionaries who are living in Cherokee territory in Georgia, and Georgia is going to pass a law to forbid white men from living on Cherokee lands unless they obtain a license and swore an oath of loyalty to Georgia. So these missionaries would have to obtain a license from the state government saying that they were allowed to stay on the Cherokee land, and they would also have to swear an oath of loyalty to Georgia. Because the fear here was that many feared that these white missionaries might actually be trying to rile up Cherokee Indians to try to get them in some way to revolt against the people of Georgia. So what we see here is the Supreme Court almost changing their tune. Now, this is only a couple years later after the last ruling. It's still John Marshall as your Supreme Court justice. Not much has changed. But what they say here is that the Cherokee are a separate political entity, and so therefore they cannot be regulated by the state. They say only the federal government has the right to regulate Native American land, and that the state government doesn't. So it's interesting that they're saying here that Georgia's license law was unconstitutional, where in the prior case a few years earlier, they were saying that they really couldn't rule on the case. So it's an interesting change of tune that they had. The sad part about this court case, though, is the fact that what this meant is that that law that Georgia had passed, removing Cherokee Indians from that land in Georgia, should never have been enforced. And Andrew Jackson basically doesn't want to listen, and he says John Marshall made his decision, let him enforce it. Meaning the Supreme Court, right? They don't have a military with them. They don't have police with them. All they can do is make the decision. It's up to our other branches of government to enforce those decisions. And so what we see here is kind of a failure of our three branches and how they're supposed to be working together. And we see that they're really not working together in a sense, because the president should have made sure that that decision by the Supreme Court in this court case was upheld, but it's not upheld. And what we're going to see is Trail of Tears is going to take place, where those Cherokee in Georgia are going to be forced to leave and head out towards Oklahoma and west of the Mississippi River, leading to many Cherokee Native Americans passing away along on that trail. So those are all the court cases we're going to cover. We're going to do a general discussion of lasting impacts and then get into practice questions. But does anyone have any questions before we go into those lasting impacts? Frankie, I mean, really. Okay, so talking about those lasting impacts. So what's important to understand as far as lasting impacts are concerned, it's this whole idea of seriatim opinions and then unified opinions. So a seriatim opinion is where multiple justices on the Supreme Court are reading various opinions. And a unified opinion is where you have one justice reading the opinion for the entire Supreme Court. So even though like it might not be a unanimous decision, a unified opinion is just saying we're going to have one justice read for the majority of the justices. Whereas a seriatim opinion is saying that we might have like 2 or 3 of the majority justices reading their opinions. And the change of the Marshall Court is prior to John Marshall becoming Chief Justice. So like when John Jay, who was our first Chief Justice, we saw more seriatim opinions. We saw more multiple justices writing an opinion for the court. Under John Marshall, we saw more of a unified opinion, where it was just that one opinion being read for the court. So that is a lasting impact, because even as we move into today's Supreme Court, for the most part, we really will usually just have like a majority decision and then a dissenting opinion. So we don't really see lots and lots of different opinions being written by the Supreme Court. Sometimes you might see what's known today as a concurring opinion, meaning you concur with the majority, but maybe you concur for different reasons than what the majority is writing about in their opinion. But for the most part, we still see this concept of a unified opinion, which really starts with John Marshall. Again, with that power of judicial review that comes from Marbury versus Madison, we're going to basically see 3 equal branches of government. And so that is going to be huge, to have 3 equal branches of government in our country now. So prior to judicial review, for sure, obviously, Congress, the legislative branch, was showing their power through the passing of their different laws. The presidency, the executive branch, was super powerful. But this was really the first time with Marbury versus Madison and the judicial branch, we see that the judicial branch is going to exert their power with judicial review. And so now we have these 3 balanced branches of government that we really did not have before. We're also going to see this concept of federalism shifting. And again, this is going to come with judicial review. This in Marbury versus Madison. This is going to come with McCulloch versus Maryland, where they're talking about that supremacy clause and the power of the federal government over state governments. So the whole idea of federalism shifting is just that our federal government is becoming much more powerful, and it's becoming more powerful at the expense of the states. And then the one I keep mentioning in each of these scenarios is the whole idea of judicial review. So judicial review, the power of our Supreme Court to rule on the constitutionality of laws, the constitutionality of presidential actions. So if you think of like the different executive orders that have been not passed, but have been written and signed by President Trump on immigration. If you think back to his immigration ban that he had when he first came into office, those were all executive orders that went before the Supreme Court. And so not only does the Supreme Court, because of judicial review, rule on the constitutionality of laws, but they're also going to be ruling on the constitutionality of presidential actions. Now, it's not just like they can see a law or see an action by the president and decide, oh, we want to rule on this. It has to be brought before them. So that's just an important thing to understand. Questions before we move into a practice question? Okay, so for the practice question, multiple choice questions on the exam all follow the same format of a lot of times. Is there a way we can access these slides? Yeah, Zoe, great question. So at the end of this, when I upload the video to Fiveable, and when you can go back and review the video later, all the slides are then located. There'll be a separate link to the slides that you'll be able to access. So if you're a member, like if you have that Fiveable membership, you'll have access to all of these slides. You just got to give it 24 hours. And then when you go back to Fiveable and click on past streams and click on this one, you'll see a video, this entire stream, and then you'll have access to just the slides if you want just the slides. So here is, and again, I'm so sorry, it's kind of small. Let me see if I can go. I'm just going to go into present mode for a second. So if you have questions, I'll get back to them. I just want to make it bigger for you all so you can kind of read this. So take a second to read this, and then I'll show you what the questions are. Okay, Frankie, come on. Thank you. Okay, so I'm just going to get out of present mode so I can go back to everyone here. So what I'm going to do now is show you the first question, which was just based on that passage. So question number 1, which of the following is not a result from the Supreme Court ruling above or similar rulings by the Supreme Court in the early 1800s? So which of the following did not result from the Supreme Court ruling above? So we're talking about McCulloch versus Maryland, which was from above, or similar rulings by Supreme Court in the 1800s. A, the recognition of federal power over state laws. B, the promotion of regional interests over national concerns. C, the assertion of the primacy of the judiciary. Or D, the court determining the meaning of the Constitution. So if you haven't all yet, so we got a couple B's coming in. The promotion of regional interests over national concerns. Anyone else want to take a guess at this? Give everyone a second here. B or D, probably B. Okay. So all of you B's are correct. This ruling, like most of those issued by the Marshall Court, did not promote regional interests over national ones. Generally, the Marshall Court issued decisions that promote national concerns over regional ones. So just know, like, the Marshall Court is always big on promoting our national issues, our national government, our federal power. So awesome to all of you for getting that correct. I have another one to go with the same passage. I actually have 2 more to go with the same passage, but let's just do the first one here. Don't jump into the second one yet. So which of the following groups would most likely have supported the arguments in that passage above? Would it be Federalists in the 1790s, Democratic Republicans in the early 1800s? I don't know how far you are yet in history, so this might be pushing it. Jacksonian Democrats in the 1830s and 1840s, or states' rights advocates in the 1850s. Again, this one might be a little bit more difficult depending on where you are. So we have one going with A. A. A or C, okay. A. All right, so the answer is A. Sorry, I'm just joking. The answer is A. Federalists in the 1790s, right? They emphasized the power of the federal government. Remember, John Marshall is a Federalist. So Federalist ideas and power were reinforced in the late 18th century by the Marshall Court's decision. So A is the one. Nice job with that. And if we go into this second question right underneath it, the ideas expressed in that passage above can best be understood in the context of debates over A, the authority of different branches of the federal government, B, the scope of the federal government's role in the economy, C, the relationship between the federal government and state governments, or D, how to match democratic political ideals to political institutions. Frank, you gotta move, bud. Okay, we got 1 coming in for C, 2 for C. Another one for C. A, question mark, all right. So the answer is going to be C. John Marshall's ideas in this passage explicitly address the debate about the relationship between the federal government and state governments. His ideas can best be understood in the larger context of those debates. So again, keep in mind, right, the whole idea is the federal government the state government in McCulloch versus Maryland doesn't have the right to tax the federal government. So that's why it's C. They're talking about that relationship between the federal government and the state government. So I know it's sometimes hard when I show that passage ahead of time and then jump to the questions that you don't have the option to go back to it. Any questions though? If you want me to explain for any of these why an answer was not correct, I'm more than happy to do that too. Just let me know. Or if there's any questions in general, I can ask about anything that was discussed tonight. I'm happy to do that as well. All right, folks, if there are no questions then, I'm just going to kind of remind you all once again of what's coming down the pipeline as far as APUSH is concerned. We have a full schedule. Oh, how long was Marshall Chief Justice? Awesome question. So John Marshall was Chief Justice from 1801 to 1835. So for 34 years. So that's a long time to, have an influence on the Supreme Court when you think about it. That's a good chunk of time. And it's funny too, because when you think about it, like, right, so I'm a history dork, so I think about this all the time. Like our presidents, at the most, they might be able to serve like 10 years if they came in and took over someone else's term and then got elected 2 more times after that, right? But our Supreme Court judges or any of our federal judges, that's a life appointment. And it's interesting because those aren't elective positions, right? So we're trusting our government leaders to put someone into a position that they could be there possibly for life. So you could have a huge amount of influence in a long stretch of time. Now, federal judges, Supreme Court justices can be impeached. So it's not like they can just get away and do anything while they're there for life. But still think about it. I mean, that's 34 years is, someone do the math, like over 4 times, 3 to 4 times longer than what a president can serve. So that kind of, like, in my mind is mind-boggling. But again, I'm a dorky history teacher. So any other questions though? That was an awesome question. So just coming down, finishing up this week and then going into next week as far as what APUSH has to, I don't know if this was the answer, but what are Jacksonian Democrats? Oh, okay, awesome question. So Jacksonian Democrats, when Andrew Jackson becomes president, when he's running for office, during that time span, the 1820s, we see that the Democratic Republican Party splits. And so there's going to be a portion in time where we're going to have what's known as the National Republicans, and then we're going to have the Democratic Republicans. So the Federalists have kind of long died out. For a while, we had this time during Monroe's presidency where we have basically just one political party, which is the Democratic Republicans, but then we're going to see that change. And so what ends up happening is the National Republicans will later become the Whig Party, and those Democratic Republicans will end up becoming the Democratic Party. And it happens when Andrew Jackson becomes president. So that's why a lot of people refer to them as the Jacksonian Democrats. But technically, Jackson is the first president of the Democratic Party we have today, although what the Jacksonian Democrats stand for are completely different from what the Democratic Party stands for today, which is why sometimes they like to put that Jackson in front of the Democrats just to decipher that Democratic Party from today's Democratic Party. But you'll see, like, all of our political parties, like the Republican Party in the 1860s, when it first gets started under Lincoln, is completely different than the Republican Party we have today, right? Because times change and issues change and things happen. But that's why it'll be referred to as Jacksonian Democrats. Anything else as far as questions? And actually, Carter, that is a good segue, because coming up right after this, in 10 minutes at 8 o'clock Eastern Time, 7 o'clock Central Time, you can learn about the rise of political parties, where the various different political parties in our country, starting in the very beginning with the Federalists and then the Democratic Republicans, or some people refer to them as Jeffersonian Republicans. You can learn all about that coming up in just a few minutes. Another history teacher is going to be doing an awesome stream all about that. Tomorrow, regionalism in the early 1800s and the War of 1812. Thank you. You set me up well, Carter. I mean, it was good teamwork there. Regionalism in the early 1800s and the War of 1812 is going to be tomorrow at 6 p.m. Central. Next week, we have a full load. So we have the Market Revolution on the 21st at 7 p.m. Central. We have key documents looking at the Age of Jackson on the 22nd at 7 p.m. Central. We have Manifest Destiny, its impact on the 23rd at 7 p.m. Central. And then I'll be back next Thursday for writing in period 4. And we're going to cover all the possible writing, right? So we're going to look at short answer questions. We're going to look at long essay questions. And we're going to look at those fun document-based questions. And they're all going to focus on topics from period 4. So if you're studying period 4 now, it'll be a great review tool just for period 4 in general. But also, it's going to be a very interactive session about the best ways, best practices for answering all types of writing assessments on that APUSH exam. So if there aren't any more questions, I want to thank you all for an awesome night. It's rainy like crazy here in New Jersey, so this was a nice break from all of that. So thank you. And those slides, back to that question that was asked originally, just give it some time, but definitely by like tomorrow morning, those slides and everything, as well as a video from tonight, will be up there for you, and you'll have access to all of that. Thanks so much for a great night. Remember, you can find us on all the social media, Twitter, Instagram, YouTube. Send us questions. If there's topics we're not covering that you're learning about in class and you want us to cover, please let us know, because we're always looking for new ideas to cover. And of course, let them know how much you love APUSH, because that's always an awesome thing. All right, folks, thanks so much. Have a great night.